I'm Jen Berger. A lot of you may have seen me before at the Office of Tenant Advocates Summit. I am a big fan. I've been going for 12 years, ever since I started working at Legal Counsel for the Elderly. I supervise the eviction prevention team, and we now are a group of 11 total between attorneys and social workers. We have 2 social workers who have a combined over 50 years of experience doing work with seniors in the District of Columbia. So this presentation, just so you make sure, like if you wanted the presentation on automobile repair, you're in the wrong room. This presentation is about the rights of people who are elderly or have disabilities. And there is a lot of material. I'm very excited to give this presentation because over the past year or two, a lot has changed. And given a lot that we see in the office, we go out and do outreach a lot because we want to make sure we hear from you as early as possible when you first see a problem. I view you all as ambassadors. So it's not just about the information you're getting today, keep staying in with you. It's about sharing that information with your friends. And your friend shares a problem with you and you say, you know what, I think I've heard about this, and then show them your PowerPoint and give them our number. Thank you. So we just need the clicker. Oh, perfect. So we're just going to address one technical thing, and perfect. Okay, thank you so much. So this will enable me to walk around. I'm from New York, so I like doing that. And let's move forward. And what I'm talking about is on this sheet too, the packet, the bigger packet that you have. If you want to keep that out in front of you, because it may be harder to see the screen, then please do that. And I don't mind if you look like you're reading, but you don't have to read ahead. We'll be talking about this as we go. All right. Okay. So Legal Counsel for the Elderly is a not-for-profit agency that works with people who are 60 and over with a variety of different legal matters. We help people get the public benefits to which they're entitled. We help people who have consumer issues, who have home ownership issues. We help tenants, of course, and we help people with wills and powers of attorney. So if you've been putting those off, we do them for free. Keep that in mind. And we help people who can't leave their homes. We come to their homes with our home visiting project. And there's a couple of people in the audience who can attest to the fact that we go and visit people, we do presentations, and make sure we help seniors stay where they are. We have self-help offices throughout the District of Columbia that help people fill out forms like if they need a new driver's license or they need a real property tax credit. And then Senior Medicare Patrol is actually here today. They help people understand their rights under Medicare to avoid fraud, waste, and abuse. And then we have a long-term care ombudsman. We see seniors through, if they're in nursing homes, assisted living facilities. The goal is that people get to return home. And the ombudsman program helps people leave nursing homes, get home with the level of care that they need to stay housed. Because when people are in the communities, they're happier, and it also costs less. So that's our goal. And I talked a little bit about eligibility. If you're turning 60 in this calendar year, 55 if there's a Social Security issue, that's the one exception. If you're a DC resident earning at or below 200% of the poverty level, the clicker's not working, so I'm having a little bit of a, but that's okay, yeah, thank you. That's okay, I'll move over back and forth. And if you don't need to be an ARP member, there are a lot of times that people will call us and say, I'm an ARP member or I'm not an ARP member. You don't have to be in order to get our services. So the Alternatives Project that I supervise is a social work legal volunteer collaborative that helps people stay in their apartments. The goal is to get referrals from community members, including, believe it or not, property managers. We have a good rapport with management. However, when we need to sue, we sue. That doesn't impair our ability to represent people, but it enables us to get the scoop, to find out, did someone fail their housekeeping inspection and is at risk of losing their voucher or their subsidized housing? And we find that out early by having a good relationship with the housing authority, having a good relationship with property managers. So much so that one of our volunteers in retirement She used to be a vice president of a property management company and then wanted to volunteer with us. And she's still with us after a couple of years. So it gives you the idea that there's a community of people who are out to find out whether someone's at risk. And the best people to find out often are property managers who are there in the community. Social workers, if they are working with clients, we train them to identify legal issues that affect our clients. And what kind of social work interventions? I'm going to just talk about this in slight detail. Our social workers go out and talk with people who may need that further assistance. They give them assessments to find out what their medical needs are and what other needs they may have to help them stay where they are. If someone has housekeeping issues or money management issues, our social workers help them link with services, not just that deal with the immediate issue, but deal with the long-term issue. And that's why powers of attorney are so important. If you have a trusted friend or family member, a member of your church, somebody who you know will have your best interests in mind, prepare those documents ahead because they will help you get the assistance you need if there's a time you can't appear in court, for instance, or you can't do other things that require you to leave your home as much. That power of attorney can help you. And the legal advocacy we do, we are not restricted by our funders in terms of what kind of advocacy we could do. So we're at City Council advocating for your rights. The Elder Disability Bill that I'm going to talk about and the Tenant Opportunity to Purchase Act protections for seniors and people with disabilities, that had to do with advocacy that we and other providers engaged in the community. We are a squeaky wheel reminding Council that we are there for seniors, that seniors have rights, and that there are a lot of seniors in the district. So we engage in that kind of advocacy. We do basic eviction prevention work. We sue when there are repair issues, when there are illegal rent increases, when people need reasonable accommodations to be able to stay where they are. And we help people pursue discrimination complaints when when a prospective landlord doesn't take a housing voucher. And in fact, a lot of people don't know this, we have outreach at DC Housing Authority every Tuesday so that they can tell us which people who have vouchers are at risk of losing their vouchers so that we don't wait until we find out about a court case. Yes? And then I'll get you.
I know some people that actually use your services. So is the information here?
At the very last slide, you'll see our legal hotline number. But at the end, I can keep a list. If you give me a name and phone number, if you have it, we can call them. But they can also take the initiative and call us as well.
Okay, well, I'll just kind of give it sometime.
Yeah, that's fine. There's a question over here.
Yeah, thank you. In terms of the eligibility, I assume that persons have to meet each of those criteria. Turning 60, DC resident, low income.
You are correct. And there are some limited exceptions. Sometimes we represent buildings, for instance, where a couple of people are under 60. But because we're representing the whole building, we'll get an exception. So there are sometimes that for policy reasons or other practical reasons, not wanting to make someone else come in and learn everything about the case just for 3 cases, then we do make some exceptions.
So can you have someone who doesn't meet this criteria represent someone who does, or someone on their behalf with the individual themselves?
We would represent we'd have a retainer directly with the individuals who need our assistance. Yes? We're funded in a variety of different ways, both with AARP money and public money. DC Bar Foundation has a large right to counsel grant. Department of Housing and Community Development. No, we're not a city agency, but we are funded by other city agencies. So yes, ma'am. And these 2 questions and then we'll move on.
In terms of custody, finding custody for grandparents, do you do anything?
Grandparent custody, we sometimes are able to place those cases with our pro bono project. That was one thing I didn't mention. The reason we could do so many wills for people and powers of attorney for people is because we have private law firm attorneys in the District of Columbia who help us with those cases, and sometimes they help us with custody cases. And law school clinics also help with those cases. Yes?
In terms of the eligibility, do you only help people that have vouchers or are low income?
It's about being a senior, not just people who have vouchers. We help people who are in rent control apartments. We help people who are in subsidized housing. We help someone if they're low income and they are seniors. All right. One last question?
Yeah. Like you move into another apartment, how many days this will give you time enough to move up this move into one apartment and move to the next apartment?
It depends on the circumstances. I can talk with you. Why don't I talk with you separately about that afterward? But, well, this is one. Yes.
I'm saying you come to the resident and you
Yes, yes. If there are a lot of seniors in a building, I want to know about that because we can do outreach. But I can talk with you a little more after. Usually you can negotiate as a reasonable accommodation. I'm going to talk about that in more detail. So,
And you don't need to tell them not to take all your stuff out.
you know what I'll do? I'll bring up your example when we're talking about reasonable accommodations because that will be relevant. Importance of housing. Without looking, why is your housing important to you? What does it mean to you? It's your safety and security. What else? It's what? It's your home. It's your identity. What else? It's your palace. Did you ever come home when the day is crazy, you see what's going on in the world, and you just take off your shoes and you just sigh? That's your place of safety. So your home is very important. We want to help people keep their homes. Common threats to housing for people who have disabilities. Employment. If somebody can't work anymore, their income's restricted, but they're in an apartment that they were affording when they worked, that can be an issue. Memory issues, even when someone has the income, can keep someone from paying their rent properly because they may forget to pay their rent. And that's a big sign of an issue. Non-payment of rent cases are 95% of the cases in landlord-tenant court. So those are the cases we hear a lot about for seniors. Housekeeping or hoarding issues. A lot of times it's just about the fact that it's harder to keep up your house as you get older, or sadly, if you've lost family members and you don't want to discard items, but your apartment is not big enough to subsume all of those items, our social workers work with people on that. And then maybe there's an issue with guests, people who are there to help you, but not complying with the lease. So you have to be careful who you ask to help you. And then support animals that are not registered. We'll talk about that in more details in a bit. And then if, the supportive services, I talked about guest behavior, repair issues that threaten, if you have a voucher, if they threaten your voucher because the landlord could end up having their subsidy terminated because of the repair issues, we have a project dedicated to that very issue. We're going to cover that on another set of slides. So you mind if we wait until we... Yeah, because we have a lot of slides. I talked about the Alternatives Project already, so let's go forward. Okay, I want to get to the nitty-gritty of this topic, which is special protections for you. So under the Elderly Tenant and Tenant with Disability Protection Amendment Act of 2016, which was hard fought by a number of advocates, seniors who are 62 or over and individuals with disabilities are exempt from rent increases resulting from housing provider petitions. That was much more than we ever dreamed of getting. However, people wanted to pick away. Let's be honest here. AARP is a huge membership organization, and seniors are a very sympathetic population. People with disabilities are a very sympathetic population. No one really wants to see them displaced. And believe it or not, including housing providers, they understand the need to age in place. So for all kinds of housing provider petitions, if you are a tenant of a rent control unit, seniors and people with disabilities are protected. Now there's a certain income level, and I won't get into the nitty gritty of that, but if you have income of less than $2,000 a month, you'll be fine, and it actually covers even more than that, 60% area median income. And the bill also does something really important. What we were seeing time and again is that people's Social Security, which is the sole source of income for many seniors, was being outpaced by the Consumer Price Index, and their rent increases were eating away at their income. So the law changed so that people's rent increases will be the lowest of either the Consumer Price Index, which is an economic indicator, Social Security cost of living allowance, or 5%, whichever is the least. And that is much better. That will spare seniors from having increases that are greater than their Social Security cost of living allowance. Yes. These are all, this is right now, I'll let you know when we're talking about federal law, but right now we're talking about DC only. And I wanted to get the definition out early, not to be too legalese, but I give you a lot of credit for your intellect. I mean, you're going to take this document, and this is going to be something that you'll keep as a resource. So I don't want to hide the ball. If you have internet at home, you can look up more. So the Americans with Disabilities Act, this definition of disability guides a lot of the protections for seniors and people with disabilities. But seniors, it's about age. It's 62 or over. But for people with disabilities, the American with Disability Act definition of disability applies. And it's a physical or mental impairment that substantially limits one or more major life activity of an individual. Doctor usually can very easily determine that and write something up, and that would be the proof required. I'm not going to bog you down too much with those details, but you have it here. So I just wanted to give you more information, and again, I have more slides than we're going to be able to cover today, but I wanted to give you information about how to get those rent control protections for seniors and people with disabilities. There is a form that you need to fill out, and then you provide that to the Department of Housing and Community Development's Rental Accommodation Division. And basically the form for seniors would be, here's a picture of my driver's license, I'm 62 or over, boom, that's it. For disability, you're going to have to attach something that's proof of disability. It could be something as simple as if you get Social Security disability or supplemental security income. But you don't have to do that if you're 62 or over. Just keep that in mind. Yes? Oh, there's a question. No. Actually, I just want to, that is not retroactive. You have to affirmatively fill out the form. If you need any help filling out the form, go to your rental office, and they need to provide that. But then you can call us. We'll help you fill out that form. Yes?
What is the difference with a tax credit apartment? Because that's not eligible.
Good question. If you are in a low-income housing tax credit property, this does not apply. This applies to rent control units. And those are units built pre-1976 and units that are where the owner of the units own more than 4 rental units in the District of Columbia. So it's really important that this slide, actually, you led into the question, that slide with your question, the effective time of your lower rent level is going to be the next month immediately after you have provided the form. So it's really important to fill out that form right away if you have not done so. And it's so, as the third item says, you're not entitled to a retroactive. You can't go backwards. Okay. Yes?
This might be a little silly.
There is no silly question because everybody else is thinking it.
I don't believe too good to be true what I'm thinking. If you're disabled, does that mean you can come in with any amount of money, or do you have to stay on the property?
What is that? Can you clarify that question?
Okay, well, maybe you could go back.
When somebody,
I can't see the writing, but if you mentioned that disability and
and 62 or over.
yes,
Yeah.
that's correct. Now, does disability mean that you can come in if you have over the poverty amount?
Not, okay, so if you're talking about housing provider petitions under rent control, it's 60% area median income, which is over the poverty level anyway. It's about like $50,000 a year in income. So, but if you're talking about elderly disability status under rent control, anyone who's a senior has a disability can fill out that form. That is correct. Right. Yeah. But not for the housing provider petitions. Those housing provider petitions that seek to increase rent beyond the level of rent control, those more extreme petitions, hardship petitions, capital improvement, substantial rehabilitation, that's 60% area median income. Yes? No, you're bringing up a really good idea, though, that we have thought of that I'll talk with you about offline because it's being recorded. So we don't want to, reveal our secrets. So the Tenant Opportunity to Purchase Act, it was changed recently regarding single-family homes, and this was a hard-fought battle. The advocates for tenants didn't want any exception to the Tenant Opportunity to Purchase Act because that is what protects you to be able to maybe purchase your building or your unit, your rental unit, if there's a sale. But keep in mind, if there's a sale of your apartment building or your rental unit, if you're renting a single family home, you get to remain post-sale. No one can evict you without a proper basis. So, and that has to be done in landlord-tenant court. So stay put. There are many opportunities to negotiate, but previously, before this law, the tenants who who are in a single-family home or an accessory dwelling unit, which is like a basement unit in a home where the owner's living, or a condo that they're renting out, would be covered under the Tenant Opportunity to Purchase Act, which means when the owner wanted to sell the property, had a third-party purchaser, they needed to tell the tenants. Now, if you're a senior or you have disabling conditions and you entered a lease before March 31st, 2018, to move in before April 15th, 2018, it's a little confusing, you're still protected, but everybody else is not. And that's because we hemmed and we hawed and we cried and we said, no, I had an active case at that time where my client wanted to remain in her unit with her granddaughter who had severe disabling conditions. The whole single-family rental was modified based on her granddaughter's disabling conditions. And I had that client come and talk with Councilmember Bonds. And so the point is you can speak up and you should speak up. But as someone who's a senior or has a disabling condition, you're still, if you enter a new lease after that is after March 15th, 2018, you're not covered. So it's only about leases that were entered into prior to March 31st, 2018. Yes?
What exactly do you mean by new lease?
That you move and then you sign a lease with but that's the typical situation. There may be a circumstance under which you entered, you're entering a lease to occupy. The insinuation there is that you actually are physically moving in at that time, before April 15th, 2018. Yes? Doesn't make a difference. Month to month doesn't make a difference. So in the District of Columbia, being a month-to-month tenant still means you're a tenant, and they can't evict you except for a proper basis under law. So when your lease ends, your landlord may say to you, you need to sign a new lease. Now, if you're in federally subsidized housing, you have a voucher, that is true. You need to conform with those rules. They're a little different. But under local law, if you're a private renter, you don't have to sign a new lease to stay in that apartment. You just become a month-to-month tenant, and you have the same rent control protections as before, as long as it's under rent control. Yes? Yeah, and you can, with the voucher, do that. There may be circumstances under which the landlord is going to have you sign a new lease when you have a voucher. If the landlord asked for a higher rent level from the housing authority and they got it, that may possibly change the lease. There are circumstances where that may happen. So let's move on. And if you rent an apartment in, for instance, Upper Northwest, and they want to convert the condos, you as, if you're 62 or over and or have disabling conditions, you qualify for an exemption under rent control. And so, under the Condo Conversion and Sales Act, you do not have to move. You stay on as a renter, and your rent increases are the same as they would be if you were a rent control tenant. The same. Nothing changes. But it's really, really important that you keep in mind that, and you won't be evicted, that's limited, that you can't waive your rights. So if you leave with one piece of information today, please, please do not sign something if you don't know what you're signing, if you haven't obtained legal advice, because the worst thing is when we have someone come in and they say, we agreed to move, and I say, did you know what you were signing? They say, yeah, I kind of knew. I thought that was my only choice. And there may be something we could do to argue against that. It just makes it harder. And that's why I'm here. So if you have something that you think is really important, that you're not understanding, that you receive from your landlord, and they want you to sign it, it doesn't hurt to just call and we'll talk with you. We'll look at your documents. And if people are receiving those documents in your building, we can come to the building and explain it as a group. So for condo conversions, just keep in mind that there are bases for eviction, A, B, and C up here. But that's with any tenant. So again, you get to remain in the unit if you're a senior and or you have disabling conditions. And it talks at the bottom of the page about the waiver. Do not sign a waiver if you don't want to move. Mm-hmm. You mean rent control? Or are you talking about rent control?
I don't know. I just know the buildings don't. You have a voucher to get in there.
Uh-huh.
You just need to get in, and it's in the building.
That's different, yeah. And if your voucher is associated with the building, okay. And then you would talk with management to see how you would go about getting one, because you can get on the list for that. We'll talk individually about that, because that's an important question. So just to reemphasize, not only do you get to remain as a tenant in a condo conversion situation where everyone around you may be in condos and you're in an apartment still, but your rent will stay the same as it was before, except for the regular rent increases for seniors and individuals with disabilities under rent control. No, they really don't. In DC, that doesn't really apply in the same way, because they would be month-to-month tenants, and but if they're in the middle of their lease period, they're still tenants. They're not holding over, but they're month-to-month tenants after their lease ends. So we just want to make sure that you know that what the different qualifications are, and I've already talked about that. But sometimes you hear something and you need to follow up and read it again afterward to understand. And this is just giving you some definitions of the income levels that are required depending on your household to be eligible for that benefit of being able to remain post-condo conversion. Now we're going to talk about a more broad discussion of the rights of individuals with disabilities under both local and federal law. And I will tell you that the reason my job is so fun is because every time people see me in landlord-tenant court, or one of my colleagues, they say, what do you want? Because basically, when you're representing seniors, there almost always is an argument for a reasonable accommodation. And the idea behind a reasonable accommodation is that the housing provider needs to change their regular policies and procedures, not go full force ahead, and make sure that they allow you to equally enjoy and use your property just as somebody else who is not a senior. And the idea behind that is that under federal law, the three laws under Federal Fair Housing Act, you have a variety of different rights. And local law, the DC Human Rights Act, is a vibrant law that I'll talk about shortly that covers a lot of different categories of discrimination. So, as I mentioned, the DC Human Rights Act covers several different categories of discrimination. Keep in mind that age or disability is on there. If you have a voucher, a housing provider cannot unduly deny your application just because you have a voucher. That's called source of income discrimination, and we've helped people with those cases. Familial or marital status, if somebody is in a partner relationship or common law relationship, they should be able to add that person to their lease. Sexual orientation, someone can't be discriminated against based on their sexual orientation. And political affiliation, if somebody's a Republican, for instance, a landlord can't say he can't rent to you. That's, we're going to talk about that in more detail, but you can add somebody to your lease as long as you're not violating occupancy guidelines. For instance, if you have a one-bedroom and you're just seeking to add one person, that should be fine. If you're seeking to add somebody as a live-in aide to help you, you would do that as a reasonable accommodation request. If you have a custodial relationship relating to them, then that would be that's something that you can present to your landlord, and that's familial status. That's a great example of a different relationship that is also covered under familial status.
Ms. Bird, I wanted to ask you something about familial status. I went to apply for this apartment. My daughter went with me. It was a senior citizen building. It's brand new. When we got there, the girl asked me, I had already been approved. She called me back on my ass. I had laughed at this one. It said, widow. I am a widow. She said, Miss Lane, I don't know what that means. Then she called me back at the second day and said, if you're a widow, please send me documentation. And it's dead.
Why was that why would that be relevant?
Right, and why would she be asking me, a dead spouse? You want documentation. So I went to report her, and I went out and I found out where they were located in Gatesburg. And I went all
Oh, I know what property that is, yeah.
Yeah, and they treated me bad when I got to this lady. She was all mean.
Well, so we can cover all the material, I just want to make sure I highlight, because it's a really good, your questions are great. Your questions are leading me to tell you more information, which is that somebody cannot ask you a bunch of different requirements because they meet you and you could tell they're sort of dodging you. Now, there is a building that had asked clients to have a sponsor. And sponsor is code word for keeping out people who are socially isolated due to mental illness, and being completely blunt with you. And that is not okay. That's discriminatory. We had a case where somebody emailed recently and said, your client shouldn't be living in this private apartment. He can't maintain on his own. He's dropping his keys. Well, if everybody who dropped their keys or lost something had to get displaced, I know I would be displaced about 100 times a year. So just keep that in mind. If you sense somebody, let's keep going a little bit, and then we could talk after. But
I had one of them ask me for my bank number.
now, if it's federally subsidized housing, they're in their income based. They can ask you for your income related information. Well, let's talk further separately about that. So under the Human Rights Act, it is illegal to discriminate against somebody based on their disabling condition, which includes refusing to rent, refusing to modify the apartment, and enable you to stay. We had an instance where a client used a wheelchair and was trying to get out the back door of his unit more easily, and we asked, if it's a private apartment, the tenant has to pay for the modifications themselves, but the landlord has to let them modify the unit. So we asked for permission to modify the unit, and the landlord was hemming and hawing. We said, look, this is what the law says. If you would like to be sued at the Office of Human Rights, we can do that too. And they'll tell you the answer is the same answer. So she did let us have Safe at Home, which is a great program, pay for the modifications. You just have to remove the modifications as well. And then we're going to talk in a little more detail about this. The Federal Fair Housing Act also prohibits discrimination on the basis of disability. So it's really important to know you have federal and local coverage. So whenever we're defending against an eviction and we think there's a disability-based reason why they're suing, any breach of lease case, for instance, that alleges that the tenant's behavior is not complying with the lease, if the tenant has mental health concerns and needs an adjustment in their medications, for instance, then that could be a reason why their behavior is the way it is, and that should the landlord should pause and let the tenant work with somebody to help them with that, as opposed to being insensitive. That's a good follow-up question. The question was, what if someone poses a safety hazard? There is a limit, and we will talk about this shortly, to the housing provider's requirement to provide accommodations. So for instance, if somebody only feels safe if they have 10 pit bulls, and those pit bulls are attacking other residents when the tenant brings those pit bulls out, that's a direct threat. It's a direct threat exception to the Fair Housing Act. So again, the Federal Fair Housing Act prevents the housing provider from refusing to accommodate the disabling conditions of the tenant and provide reasonable modifications, changes in the rules, policies, and procedures to enable the tenant with a disability to equally use and enjoy their apartment. And the idea behind this and the mission of our organization is to enable people to age in place with dignity and purpose. And they can do that if housing providers pause and don't say, I can't do that. It costs me too much. And that's not a basis to deny an accommodation. So the other thing is design and construction. So a housing provider needs to, if they're a public or subsidized housing provider, provide accessible units, especially when they're constructed in the post-1990 era. They have to be accessible. Then they have to make sure that they provide accommodations when the tenant asks affirmatively for grab bars. However, I should add that if the housing provider has reason to know that somebody has a disabling condition, even if the person doesn't affirmatively ask for the help, the housing provider should accommodate. That is our argument, and that's what case law also says. When I say case law, I mean court cases that have been decided that are of significance. I don't want to get you too bogged down in the legalese, but I wanted you to have the set of law that supports people with disabilities. Section 504 of the Rehab Act is another law that helps make sure that people can live with dignity and self-determination in their communities. Yes?
I don't want to take you off on a tangent, but some people no longer have leases. You can get a lease for a year and then you're off the lease.
Yes, that's what we mentioned before, that you can continue to live with a month-to-month tenancy.
So are there any differences in how things are handled if you don't have a lease?
You should be treated the same exact way, no difference. Because in the District of Columbia, an eviction cannot occur just because a lease ended. An eviction can only occur if there's a proper basis for eviction under the Rental Housing Act. And that's non-payment of rent, breach of lease, criminal activity, or one of these notices that the landlord could successfully serve, like personal use, a 90-day notice for personal use, where they say they want to live in the unit. Well, because the lease does set the circumstances that govern the tenancy, including the landlord's obligations. So a lease, most of the time, is helpful to tenants. Some clauses may be outdated. So you could get help negotiating your lease. The Rehab Act applies to public housing owned by DCHA, DC Housing Authority, and HUD subsidized housing. It does not refer to the voucher relationship, but it does refer to DC Housing Authority and other HUD subsidized housing. The tax credit program, I don't think so, but the Fair Housing Act would. So the American with Disabilities Act, I just wanted to include further information, further clarification. And there were some amendments that just, again, they broadened the definition. Instead of having a limiting list of quote-unquote impairments that someone could have to be qualified as having a disability, it's a non-exhaustive list, meaning someone could be considered having a disability even if their disability isn't on the list. And an interesting example is that when we have people who have a lot of items in their apartments, and they are diagnosed as having what they call hoarding disorder. That is what they call DSM-5 diagnosis, meaning there's a psychological diagnosis, and that can be a basis for a reasonable accommodation. And I'll talk about a case that talks about that after. Housing providers, then you were talking about this a little bit when, I'll get to you shortly, when you were asking your question before about your application to an apartment. Housing providers can't ask tenants if they have a disability. If the apartment, though, is a disability-related apartment building, then they can, but only as appropriate to establish disability. They can't ask for information generally about the ability to remain in the community independently. And I have seen time and again housing providers, and this is why we train social workers on the fair housing law so they can let us know, they're great witnesses. If a housing provider says this, they often have said they shouldn't be living in the community. They need to be in a nursing home. And I say to them, do you want to be in a nursing home? Or do you want to remain in your home for the rest of your life? And it's not a bad thing to be in a nursing home if that's where someone wants to be and chooses to be, but that's the question. They can ask if you can comply with the rules of the tenancy. And that, like, can someone keep their apartment clean? And someone could say, yes, I have a housekeeper come every week, or I have a home health aide come, or my daughter comes and helps me clean the apartment. And is your income within the income requirements? They can ask that. And they can refuse to rent if you can't meet the tenant obligations, like a credit check, and if your income won't meet the rent. Generally, the rule of thumb is that 30% of your monthly income should be what the rent is, but I know many people pay more than that.
I know you're running out of time, but I'm going to say this real quick. I'm a CNA, used to be.
That's a CNA, Certified Nursing Assistant.
Yes, certified nursing assistant. And once you turn up on 50, they say, like you dead. We still alive. Even I'm almost 60, I'm still alive.
We have a number of...
Attitude of them.
Well, and the thing is, the key is to remain active and vibrant in the communities to dispel stereotypes. So it's really important to push against those stereotypes. But let's keep on topic. What is your question?
I'm going to ask, they had put a new bathtub in my bathroom, and they didn't put nothing up there. We need to hold up the whole on, because I'm on disability too.
So grab bars is an issue.
Yes, but they don't since I don't fail, I have broke my collarbone. I just got my surgery done this year.
So grab bars are something that if you live in a federally subsidized unit, meaning DC Housing Authority, public housing, or what they call site-based Section 8 or project-based housing, where if you move, you lose that unit, they are obligated to add the grab bars. If it's a private apartment, then you would have to pay for them out of pocket.
No, I took them, they give me a U-tub, a U-bathroom tub, but I didn't have enough to hold on.
Right, and if you ask for that accommodation, if your landlord is a subsidized landlord, they need to provide that accommodation at their cost. Yes, one more, and again, let's not talk at the same time, just it's harder to hear. For the subsidized, what I'm referring to is DC Housing Authority and site-based, where the building is HUD, Housing and Urban Development subsidized. Not a tax credit or some other kind of arrangement like that. If the building is a no-smoking building, they can ask if you're a smoker. Smoking is not a protected class. Smokers are not protected. So in the building, if the lease does, and that's why a lease agreement is an interesting thing. If a lease agreement doesn't prohibit smoking, and then they ask you to sign an addendum, if the DC law changes and prohibits smoking inside all residential buildings, they may be able to require you to sign that. And if that's the law, you could be violating the law, and that could be a breach, even if it's not in the lease. It could be a violation of the law, because the way the eviction statute works is it's either breach of lease or a violation of the law. So it could fit within that. Smoking issues are really always a struggle for us as an office, because we have a set of tenants who smoke and a set of tenants who are bothered by that smoke. And there was a tenant, for instance, who lived on the second floor, and the smoking area was right below her window. And she couldn't keep her window open during the time period where there was no AC and no heat. And we did ask that the smoking area be moved. There are ways of accommodating people, and also, people can smoke outside their buildings. And that's the answer if there is no smoking in the building. Well, what they can say is it's a no smoking building, and then if someone moves in and then ends up smoking, it's a breach of lease and they can get evicted. So it's not that they wouldn't, look, it's not impossible. It's not impossible, though. Types of discrimination. So there could be overt, meaning obvious discrimination, where a landlord has said to our clients, you shouldn't be in independent living, you should be in a nursing home. That's overt, outright discrimination. And then there's sometimes it's a little hidden, where the housing provider treats some tenants nicer than others, and there's a grouping of those tenants. Like there are tenants who are younger who are treated better than tenants who are older, or tenants of a certain race who are treated better than other tenants. And if that can be proven, there are organizations that sue based on that. And it's important to get that out if that's happening. And I think we talked about this before. Failure to have accessible housing is a violation of the Human Rights Act and the Fair Housing Act. And does the landlord's intent matter? If someone's discriminating, and discrimination is a violation of the law, does it matter if the landlord didn't mean it? Because maybe they were raised to be discriminatory or something? Do you think that matters? How many of you think that matters? If their intent wasn't to discriminate. How many think it doesn't matter what their intent is if they're discriminating, it's illegal? That is correct. Yes. See, you're all ready to go and train other people on this. So I just wanted to give you some more examples of accommodations that you could ask for. Time to get more services in place if somebody has housekeeping issues. Waiver of a no pet policy if someone has a therapy pet. This is interesting. In a public housing unit in New York City, a woman had lions. I'm not kidding. I am not kidding. Google it when you get home. And they, of course, were a violation. You can't actually have non-domesticated pets. There's a question in the back. Yes? Well, that's a direct threat. That could be a direct threat to other tenants, in that if they don't get services in place, they should get more time to get services in place, but then if they're directly threatening other tenants with mold and leaks, then there's going to be a limit to their ability to stay there.
Now, right now, I have black industrial bags covering my clothes in the closet. I've had my rugs changed about 2, 3, 4 times.
Well, let's.
Motorized and everything.
It's not the first time I've heard this kind of situation. I will say this. I ask you as tenants, if another tenant is doing that, if at all possible, you report it, of course, and then if you can understand that the landlord is going to have to give them accommodations. If there is a mental health issue or someone has dementia, that's what's probably going on there. That said, you have a right to a habitable apartment. So your landlord's going to have to make those repairs. So it's complicated.
They can't just say, well, you getting out of here. They're not going to do that.
It's going to be a long process because there are a lot of laws that protect people with disabilities. So
They have to go to court.
that is correct.
Oh, I see.
So it's better to try to work something out. Now, if you know a tenant is in trouble, you can call DC Office on Aging, and a more productive thing to do is to ask them to come to that unit and say, I think there's an at-risk senior in that unit. And then they may work with them and see if they can get a home health aide, and maybe the water could be shut off before the home health aide leaves, or, there's different things, creative. I believe in creative solutions where everybody could be happy. Yes?
My question is smoking and non-smoking apartments. What happens and how is that orchestrated with people who have cannabis given to them that is prescribed to them by their doctor?
So here's the thing. The federal law trumps the local law. If someone is in public housing or subsidized housing in another form, then it doesn't matter that local law is allowing someone to smoke marijuana. It's even if it's medical marijuana, because it's still a violation of the one-strike policy. But in private housing, and we did have a case, I couldn't believe it. A law firm helped a client who was growing medicinal marijuana and somehow was able to pay his rent. So I was thinking, I don't want to know what's really happening. But they were able to stay because it was a violation of the local law, and this was a local property. It wasn't subsidized federally. These are really good questions. I didn't prepare you ahead, too, and you're just helping me with this material. Transfer to another apartment. That has happened before, where we help people get a different apartment because, for instance, the tenants down the hall smoke and the person who was in that unit didn't want the smoke and they were willing to move, or someone upstairs makes noise and they were willing to, the tenant below was willing to move. If the tenant is not satisfied with their apartment and the move is because of that, they haven't been charging fees because you can negotiate with them, with the landlord. The utility allowance for medical equipment, you can get a waiver of the utility allowance because the medical equipment is an accommodation. That's the use of the medical equipment is an accommodation. If the medical equipment makes noise, you shouldn't the landlord shouldn't behold you to the noise-related regulations. I mean, keeping all of that in mind, and we all have to live together peacefully. Whether someone owns a condo in a group living situation or an apartment in a group living situation, it's always a work in progress and dealing with other people, neighbors. Accessible parking spot. Having a parking spot for one's home health aide in areas where it's really hard to find a parking spot. We've dealt with those issues. Increasing the payment standard if you have a voucher so that you can live in an area where the rents have gone a little, they've skyrocketed. And extending the time period to search for your apartment if you have a voucher. There's all sorts of different accommodations. I think that it's more likely you're going to get the accommodation because they have, for instance, when we're asking, they see that ARP Legal Counsel for the Elderly is asking for an accommodation, and we're attorneys, we're prepared to sue. And there are many avenues, and I'll talk about that shortly, where you can go if you need to get relief. And I talked about modifications a bit. Some of your questions also led into that. Modifications is a change to the unit to afford the tenant with full enjoyment of the apartment. And grab bars are an example, wider doors. And we've been able to have a lot of success in formally getting that relief for clients. Ask first, and then if you need further help, let us know. Yes?
I'm going to ask you one more question.
Sure.
We live in 2900, and we don't have no parking.
You're talking about the heat?
They have parking over there, Well, we can use, we have companies, come, you don't have nowhere to park.
Talk about 14th Street or the, yeah. And that,
If them parked it, somebody can tow your car, they got to pay $250.
and there's an ability to get handicap, obviously the hang tag that could help with that situation. There could be an ability to get out of a ticket if it's towed away, and there are many things that one can do to fight that. It is really difficult, though, up 14th Street, for sure. Let's move on, because I want to make sure I cover the material. Yes?
When it says physical change in units or dependent with a disability, is aging the disability also?
The manifestations of it. So how one is showing their aging process. Yep. And getting a doctor's note. Having a very good relationship with a doctor is really important. For a number of different reasons, it's good to stay healthy. And by the way, AARP generally, DC AARP is out in the community all the time doing a lot of free fairs. Keep an eye out on their website because you can. I'm going to move on, and then we're going to. I can answer your question after. How do you ask for an accommodation? How many of you think that you need to do so in writing? Only. It's good to do so in writing, but because you have proof of it, but you don't need to. It can be an oral request. You could say to the manager, and it's good to bring a friend with you or a relative with you who can hear this request. I can no longer be in my bathroom without having some grab bars, and then see what they do. So you notify the housing provider that there's a disability and that the disability affects the ability to use and enjoy the apartment or comply with the lease. And it's better to notify ahead of time of that. And you state what so you're notifying of a disability, you're notifying of the problem that, that creates for using and enjoying the apartment, and then you notify of what the accommodation is that you need. I need to have my grandson be able to stay overnight 3 nights a week. Something that would prevent you from having to get a breach of lease action later for an unauthorized occupant. And then state the nexus or link between the disability and the accommodation you're requesting, which means that you're linking up, for instance, why your grandson needs to be in your apartment. I have to take medication at night, and I don't remember to take my medication, and he helps me remember. Oh, yeah. Yes, good question. If you need to get out of your lease, then you can ask for an accommodation to do that as well. We're going to talk about that shortly, actually. So an interactive process. The landlord is supposed to have an interactive process where they converse with the tenant about the reasonable accommodation request. Often what I find in the court process is they wait for mediation, which is required by court anyway. So I say to them, that's not enough. You have to do something special and additional to the normal court process. If it's prior to litigation, if they're smart, they sit down and meet with you and talk about what you're asking for and why. And then they sit down during that discussion and talk about what kind of accommodations you need. These cases are just examples. I talked about cases involving people who have housekeeping issues or hoarding issues. I will say we work with a lot of people who have hoarding issues, and we are able to keep most of them from getting evicted. The only time we are not is if they're not cooperative with our services. But our social workers work really hard to get in, and sometimes it's really hard to get in because the door is blocked. And it's nothing to be embarrassed about. If anyone has a concern that they may be having a fire hazard in their unit and want to call our hotline, we have the number at the end of the presentation. Yes. You know what, you can, maybe what you could ask them is say, it seems like you may need some more support to stay in your apartment. Would you like me to refer you to legal counsel for the elderly, for instance? And then you can call or have them call with them, but then they can have the private conversation once you see they've connected. So let's keep going a little bit more, and I do have some more resources at the end. This is, yes, and also Wes, I'm going to ask you to take a picture. I'm going to take a, whoa. Okay, excuse me. Did someone have a question? Yes, sir. Can you take a picture of me? I promised her. And the audience. What the implications of what kind of letter?
Notice of transfer of ownership interest.
Let's talk privately, because that's a personal, my thing is not giving legal advice as in a group, so we should talk. I'm happy to stay after, and
Familiar with this kind
I am, so let's talk about that. So no pet policy. So I met with the ASPCA and the DC Housing Authority to talk about their pet policy, and we gave them a lot of feedback as to what kind of pets, what kind of care is needed, and they wanted assurances that if there's a pet in the property, that the pet would not harm other residents and would be cared for properly. If someone needs a pet for a reasonable accommodation, the pet does not have to be a certified animal with the, a help animal, excuse me, with the, you see those adorable golden retrievers. I have a golden retriever at home. If you want to see a picture, you can ask me after. But I often want to take him to work. You just put one of those red vests on, but you're not allowed. But if you need an accommodation, your doctor sends a letter, provides a letter saying, in order to reduce anxiety, for instance, my client needs a cat. And then you provide that to management. And management says, yes, you can have the cat. As long as the cat doesn't destroy the property, and you're responsible for that. You're responsible for cleaning up after your pet. But if it's a support animal, you don't have to pay the pet deposit. If there's a second animal beyond the support animal, you do. So the support animal, you don't have to pay a pet deposit. Yes?
I know just if you have any kind of pet, you gotta pay $300.
If you're a private tenant and your lease says that, then that can be the requirement, but if it's a support animal, you don't need to. So if your doctor writes a note saying you need your dog because you have anxiety, then you wouldn't have to pay that fee. But you would have to pay damage as a result of your pet, like when you move out. They could withhold the security deposit for that. So service animal is broadened beyond trained animals. And that's why the local housing authority changed their rules. And the HUD guidance says that it can be an emotional support animal and as other animals that may not need training. Now, there's a limit to that. Snakes.
Oh, no.
I mean, if one gets out, I don't think any of us wants one in there. Just, and about 6 years ago, I testified at the City Council to talk about the Service Animals Access Amendment Act. And that enables persons with physical and mental disabilities to be accompanied by a service animal so they can have equal access to public accommodations. And essentially, it's a law that enables people to bring their service animals into their apartments. Now, if they're in private housing, they can do so as well. And it's just a matter of not being a direct threat to other tenants. Thank you. So, and the definition of disability for the purpose of having a service animal used to just be for people who are blind or have hearing impairment, but they have included mental disabilities as well. There's a lot of people who need support animals or need them to reduce anxiety or trauma. War veterans. There's a very big connection between veterans, Holocaust survivors, people who experience other kinds of trauma and needing support animals. The thing is, a lot of times people feel like they shouldn't say a peep if their rent is low. And what I want to empower you to do is fight for your rights. You have rights as tenants in the District of Columbia, regardless of what level your rent is. You don't have to feel like I shouldn't say something because you're my landlord. I'm on bot time. My landlord's going to displace me. Just keep that in mind. Live-in aids. I want to make it clear that just because you may need more support in your apartment, for instance, that does not mean that you need to move into assisted living or a nursing home. If you want to, you can. I mean, that's your choice. But you can also prepare with assistance from social workers in the community. DC Office on Aging has a really good network to get help inside your apartment. And if the help that you get, if you're having some problems with the agency, for instance, our ombudsman program, and you have our hotline number at the end of our brochure, can help advocate for you to get that support to make sure that you're getting the services that you're entitled to. And as you age, if you have more needs in your apartment, in your day-to-day life, then you can get an increase in your hours. And our Public Benefits General Services Unit at Legal Counsel for the Elderly helps people fight with the government to get you more hours. So there's a lot that can be done. So live-in aides don't count as household members. That's really important to remember. If you want to truly just add someone into the household because you want to add them to the household, that's one thing. But especially in subsidized housing, they're going to watch really closely who you're adding and why. If you leave that apartment, your live-in aid leaves the apartment as well. And live-in aides, I mean, they can be screened if they have a criminal background or anything like that. That would be a risk to other residents in the unit. And not all live-in aides are hired agencies. They could be relatives who are trained to be live-in aides. They could be a relative who needs to just be there to make sure someone doesn't fall because they have epilepsy, for instance. This just gives, for the voucher program, a definition of a live-in aide. It's somebody who resides with one or more elderly persons or near elderly persons or persons with disabilities, who's determined to be essential for the care and well-being of the tenant and is not obligated for the support of the person, so the rent should not go up because of the income of the live-in aide if you're in subsidized housing, and would not be living in the unit except for providing those supportive services. So the very definition of live-in aide requires that the live-in aide leaves if the senior leaves the apartment, or a person with disability. All right, the proof needed to get an accommodation. We talked about this a little before. Proof of your disability. So if you're gearing up for this, make sure you have a doctor who you trust who can write a good letter. But the letter doesn't have to have a lot of detail, just enough detail to explain why someone needs the accommodation. And you want to make sure the housing provider is aware of the disability by providing them information about it and explain what the accommodation is, what accommodation is needed to use and enjoy the residence. And then if the housing provider refuses to grant the accommodation, you need to prove that that was the case. Ask for a response in writing and document everything. So housing provider defenses, we talked about this already. If there's not a nexus or relationship between the accommodation requested and the disability, if there's an undue financial burden on the landlord, and if there's a direct threat to the other tenants in the building by having this tenant remain in the unit with whatever accommodation it is. Current drug use, it doesn't include someone who's in rehab, by the way. So the housing provider could say as a defense, you can't remain in the apartment using drugs, but if they're in rehab, then having used drugs doesn't mean that they should be displaced necessarily.
Maybe this is a stupid question, but does citizenship status count like in federal housing, where people have to be citizens?
That's a little more complicated, but yes, there's lawful permanent residency can count. But if somebody's in the household who isn't a citizen, they do a math calculation that I could talk with you about after that takes away their income. I mean, they include their income and they don't get subsidized.
I saw one application that said the landlord would be harboring a future that's been rented to
I know several situations where somebody was not documented and lived in the unit, but then they weren't counted, they couldn't get a subsidy. So if there are two people, then only half of the unit is subsidized, the other half has to be paid for. So it's a somewhat of a complicated calculation, but it does get accounted for. Yep, so winding down, how can you enforce your rights? Because it's one thing for me to tell you you have rights, and it's another to know what you can do. So if you're in DC Housing Authority housing, you can contact the ADA coordinator, which is Americans with Disabilities Act coordinator at the Housing Authority, to file a request for an accommodation. And you could also file a HUD complaint. You could just call them. It's that easy. HUD complaints are not just for HUD subsidized housing, they're for private housing too. So I've just made it really easy for you to complain if you need to. Just know that that process is lengthy. And then there's another process that's also a bit lengthy, but nonetheless can work. You can go to the Office of Human Rights, either in person or call them by phone. Your wait time, if you go in person, may be a little longer. On the website, you can also file a complaint. We do that. We file them online. Again, that process takes a bit of time before you get an interview. Could be a couple of months before you get an interview, and then that gives you an opportunity to mediate the dispute. I'm not going to get too much into the weeds in terms of legal action, but you can file a lawsuit in the Superior Court or the federal district court. And we've done that before. It's from a litigation standpoint, it's interesting and fun for me. It takes a long time for our clients. So what I find is by demonstrating that I'm willing to sue because they've seen me do it before, they kind of tend to back off and let you and get the accommodation before it gets to be out of hand. And I just wanted to, I wanted to point out at the end of the PowerPoint, there's information about resources in your community, including ward-specific social service agencies, Department of Behavioral Health, if someone needs mental health resources. So you were asking about your upstairs neighbor, if you thought there was a mental health condition. You could ask, can I call the Department of Behavioral Health with you? That may not go well, but you can, it may be that you can gain their trust. Maybe at a point they're willing to accept help. So it's worth doing so. And this is my information. I'm fine with you emailing me if you think it would be helpful for me to present to your building or someone else from my office to present. I'm happy to do that. Just let me know, make sure it's a night that you can get a good turnout, and we'll send somebody to go and talk with you. Any other questions, except for the individual questions that I could talk with after? It's on the PowerPoint. It's on the last slide. Uh-huh. Mm-hmm. You can apply for a reasonable accommodation if the request for a waiver relates to your disabling condition. The request for the transfer, if it relates to a disabling condition, there's a nexus, then the waiver of the fee could occur. Yes. Mm-hmm. Oh, yeah. You as well. You can give this, if you can give this to Wes down there. Thank you. I want to give you time to fill out the questionnaire, the surveys, and you can hand them to Wes. If you don't mind bringing them down with you, that will prevent us from having to grab them after. But don't give them to me because I'm the presenter. So yes, Mr. Jackson, esteemed is it now vice president or is it president or vice president? So what's your question? Mm-hmm. Mm-hmm. Uh-huh. Yeah. Uh-huh. Well, he could put himself on the list. So if somebody has an apartment that's too small for them based on their condition, then they can ask for a transfer and they'll be put on a waiting list. They can't displace somebody else for it, but they can look at their transfer list and maybe his apartment meets somebody else's needs and they could do a swap. But that's you get on a waiting list. So he does have to ask for it from the office. And if he can link it up with disability, that would be even more helpful, like a mobility issue if his doctor could write a letter. Any other questions? I know I'm going to talk with this gentleman. He gets first dibs to talk with me about his individual question. Yes? Uh-huh. You're welcome. Can you raise your... Yes. Yeah, we accept referrals from community members. If you can get some measure of cooperation from the person so they know that you're referring it, that would be even more helpful. And the basic information of name and telephone number is most helpful.
You talked about marijuana in a private,
Mm-hmm.
in a private building, privately owned, not
Mm-hmm.
federal. Does the law itself cover everything? In other words, you can
Yes.
grow.
Yes.
You can grow what the law.
As long as there's no federal subsidy to the bill, because otherwise one